call the Honourable David Cunliffe.
Thank you, Mr Chairman. It's a great pleasure to take a call in the committee stage of this tariff free trade agreement between New Zealand and the Republic of Korea Amendment Bill and to convey again Labour's strong but somewhat qualified support for the bill. Sir, in the time that you allow me, I intend to firstly recap on several of the principles that my colleague, the Honourable Phil Goff, has attested to note the substance of the deal, firstly in terms of the tariff reductions on goods trade, and then to touch briefly upon services and investment issues. I want to dig into the investment matter, both in its own right and in comparison to the China FTA, and finally to look at the investor-state dispute settlement provisions as they relate both to this bill and in the sequence of events, the relationship between China agreement, this agreement and the current TPP negotiations so far as we are able to be aware of them. In terms of the principles, sir, let me restate what my colleague, the Honourable Phil Goff, has just said very clearly. Labour is an internationalist party. We have a strong and proud tradition of supporting free and fair trade. It was Labour that initiated and negotiated the China FTA, for example, and we have throughout supported the government's work in this negotiation and in other free trade agreement negotiations. And I think that that is a very important and national interest driven as well as principle driven position for us to underline, particularly when we get to a later debate about the Trans-Pacific Partnership, because we attest that that is not just a free trade agreement, but a behind-the-border economic and governance agreement as well, and for that reason a broader debate is necessary. Sir, let us turn briefly to the advantages of the bill to New Zealand, and in doing so can I acknowledge the work of officials and the quality of the national interest analysis which has been provided, which while not long is nice and specific and quantitative, and not all NISs are, and this one is useful. For example, the reduction of goods tariff shows tariffs on 48% or 793 million of New Zealand's current exports to Korea will eventually be eliminated. There is a time scale where over the first 5 years, 67.4% will become duty-free. Over 10 years, 79% and at the end of 15, 97.8% of current exports to Korea would be duty-free. That is clearly of value to New Zealand, real bankable value to our exporters, not only in agricultural goods such as dairy, meat and fruit and horticulture, but across a wide range of products. There are reservations, there are holdouts, it's not perfect, no deal ever is, but it is our contention that this is a deal worth having, and we commend the work that the government and its officials have done in that regard. Of course, there are obligations on New Zealand, and they're not exactly symmetric. We start from a different position. We had lower tariffs from the get-go, so we therefore have less to reduce. So therefore it is not illogical that the time frame for that reduction is shorter, maximum 7 years. There are various protocols and cooperation agreements which have been negotiated to provide some assurance to our Korean friends that the process of liberalisation will be measured, will be methodical, will be accountable and will not be unduly disruptive. We do not think that those provisions are irresponsible. So overall, turning to the trade and services provisions, we think that they are, while not complete, worth having, and the investment measures are where we have some qualifications. Can I note, sir, though, that there is a cross-cutting issue in respect of the measurement of services and investment flows, which the Labour opposition has repeatedly highlighted to the government, which is our Department of Statistics does not capture these in sufficient granularity. And an example which is relevant was the Singapore Closer Economic Partnership Agreement, where it was postulated that New Zealand would benefit greatly from the services and investment flow gains, but may in fact, in the short term at least, lose in terms of the goods trade balance, the difficulty being that it was difficult to tell because our services and investment data, Mr. Chairman, I'm anticipating your finger poised on that, Mr. Chairman.
The Honourable David Cunliffe.
And right I was. Thank you for that opportunity, sir, to complete this. The importance is that if we want to know net whether the New Zealand economy and the New Zealand taxpayer is benefiting, it's important that we modernise our statistics and capture the newer sectors, the high-tech sectors, the services sectors, the spin-offs of the investment flows, including their externalities, as well as the relatively easier to measure flow of goods trade, which is volume times value minus the change in tariff level. So let me turn now to the investment issues. In its minority report, the New Zealand Labour Party drew attention to a potential weakness here, which we were not sufficiently assured by officials on. While it is clear that the existing reservations which we have to be able to limit, for example, the sale of New Zealand farmland or sensitive land can remain under the agreement, what is not clear is whether it would be possible to introduce new restrictions, for example, on the sale to non-resident foreign investors from the Republic of Korea on residential real estate, either a ban or a stamp duty, both of which occur in Australia. Now, there is mixed opinion about this. It is our strong hope that the government will be able to do some form of clarifying instrument, such as a side letter, and I ask the Minister if he would please to perhaps take a brief call on that matter and provide some indication of the government's, firstly, understanding of the position, because this is important in relation to other potential trade agreements, and secondly, to the extent that the government agrees there is some lack of clarity, whether they have in mind to undertake any form of clarification. It is important for our sovereignty, particularly where we have something like a tremendously overheated Auckland property market, high levels of actual inbound migration, that we're able to manage the investment flows, such as could be liberalised under this agreement, and we need to preserve the opportunity for future regulation. Which brings me to the third major area of debate, and it's not sufficient to cause us to withdraw our support from this agreement, which overall, while not perfect, is one worth having. And I repeat that, and we repeat our commitment to free and fair trade. But as my colleague Phil Goff said, we are concerned about the use of investor-state dispute resolution mechanisms, and that in common language is where a corporation can sue the New Zealand government in some form of tribunal, which is not a government forum, which is outside the normal rule of law in the partner countries. It is Labour's contention that those ISDS, as they're called, provisions can have some value where we're trading with, for example, a developing country that does not have a well-developed system, where New Zealand companies are not assured of the rule of law. So we're not saying we're opposed to ISDS in all cases. However, we do not believe that it was necessary here because, frankly, the Republic of Korea does have a well-developed legal system, and the risk of extra-legal appropriation of New Zealand property rights we would deem to be pretty low. Why that matters is because there is a sequence of negotiations that started with the China FTA, where we had a much cleaner and more robust investment provision, where there may have been more cause for ISDS, and we're now embarked on the Trans-Pacific Partnership negotiations. Now, I know, sir, that you are counselling me to stay within the confines of this bill, albeit that all parts are taken as one. But I do believe, sir, that it is a highly relevant matter to Labour's support of this bill, that we have considered whether we could still support it because of concerns that both the investment chapter and the ISDS provisions could be read in such a way as to tilt the TPP outcome to a point where we could not support it, and that, sir, in such an important call, would be important. And I do want to just set down the balance that we've struck between support for this agreement and a very important set of 5 bottom lines around the TPP, that Farm Act must be protected, that corporations cannot successfully sue the government.
TPP is not part of this debate.
Sir, I take your guidance and I will narrow the scope, But in doing so, let me repeat that we had to consider before we could support. Mr. Chairman.
The Honourable Tim Grocer.
Mr.